should the age of an adopted child be a criteria in deciding if an adoptive mother will get the maternity leaves in India or not? This is something that has been very recently clarified by the Honorable Supreme Court of India in its historic judgment. Hello students, welcome to Drishti IAS. My name is Saloni Nandkyoliar, and today we'll talk about this judgment and also understand what are the maternity benefits that are available to an adoptive mother in India. So while listening to a plea that was filed under the Maternity Benefit Act of 1961. So there was a provision under the Maternity Benefit Act of 1961 which said that an adoptive mother is going to get the maternity leaves of 12 weeks only if the age of the child that she is adopting is less than 3 months. So an adoptive mother is going to get the maternity leaves of 12 weeks only if the age of the adopted child is less than 3 months. If the age of the adopted child is more than 3 months, then no maternity leaves will be provided to the mother. This was the law under the Maternity Benefit Act of 1961. Then we know that this was repealed and the Social Security Code of 2020 came into effect last year. So this moved under the corresponding provision, that is Section 60 Clause 4 of the Social Security Code 2020. It also said the same thing, that an adoptive mother is going to get the maternity leaves of 12 weeks only if the age of the child is less than 3 months. Now this was declared to be unconstitutional by the Supreme Court of India, and now this law has been struck down, meaning that the maternity benefit or maternity leaves of 12 weeks are going to be provided to all adoptive mothers irrespective of the age of the adopted child. And this decision was made by a bench of Justice Pardiwala and Justice R. Mahadevan. So now the law says that adoptive mothers are going to get the maternity leaves of 12 weeks irrespective of the age of the child that they are adopting. So we'll discuss the maternity benefits that are available in India, and we'll also discuss the paternity leave status in India, because while this judgment majorly focused on the maternity leaves, it also raised a bigger question. It also asked us to look at the status of paternity leaves in India, because both the parents need to nurture the child. So we'll talk about all these things in detail. Now before we do that, we have this course for you, which is the Studio GS Foundation live online course. Now this is a foundation course, meaning it's a complete UPSC preparation kit. You can cover your prelims and mains syllabus at a very affordable price of only rupees 34,999. Prelims and mains syllabus, printed class notes, live chat facility, everything will be completed in 14 months only. So you're getting all of this at 34,999 rupees only. And if you wish to avail the maximum discount for yourself, you have to use this coupon code, which is SALONI, 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 all in capital letters only, and you will be able to get the maximum discount for yourself. So don't wait, admissions are open. You also have 3 mediums that you can choose from: Hindi, English and English. For any more information that you need, please call us at 87501 and you can also download the Drishti Learning app. Now let's get back to our topic and understand the rationale of the judgment. What was the reasoning of the Supreme Court? So right now, if we talk about the maternity leave status in India, so maternity leaves for biological mothers is 26 weeks for both government and private employees. 26 weeks for the first 2 children. And after that, this number is reduced. So 26 weeks is only for the first 2 children, and out of these 26 weeks, 8 weeks can be taken even before delivery. So this is the maternity leave status for biological mothers in India. And additionally, when we talk about government employees, they also get a child care leave. They are also entitled to a child care leave, which is up to 2 years, that they can take for nurturing their child. Now, this can be taken entirely in one go, or it can also be taken in parts, but this is available only to the government employees and not to the private employees, not a mandatory provision for the private employees. So this is the maternity leave status when we talk about biological mothers. Now, if we talk about adoptive mothers, this number is 12 weeks. And now the age criteria has also been removed, because when the Supreme Court talked about the reasoning, it said that when we talk about maternity leaves, when we talk about these leaves are not only meant for physically recovering from the pain of delivering a child. That's why the number is high for biological mothers. But it does not only talk about the physical recovery from pain, but mothers also use this time to emotionally bond with their child, bond with the child and nurture the child. This is something all the new mothers need to do, whether they are biological mothers, whether they are adoptive mothers, whether they are surrogate mothers. All the mothers need to do these things with their child to develop an emotional bond with the child, to nurture the child. And when we had this 3 months criteria, this was a violation of many fundamental rights like Article 14, Article 19, and Article 21. Now let's understand how. Article 14, this was against equality principles. For example, there are 2 new mothers. One mother is adopting a child that is of 4 months, and one mother is adopting a child that is of 2 months. Now earlier, this mother was getting a maternity benefit and this mother was not getting a maternity benefit. Now she is no less of a mother in comparison to her. So this was against the principles of equality. Both of them need this time to emotionally bond with the child. Both of them need this time to nurture the child. So this was against the principles of equality. It was against Article 14. Then it was also against Article 19. When we do not give maternity leaves or the choice of these leaves to new mothers in India, then they'll have to make a very difficult decision. They'll have to either choose their career or they'll have to choose their child. They'll either have to choose their job or profession, and either they'll have to choose their child. So this again was against Article 19, where they did not have the freedom to profess any profession or choose any profession, because they'll have to make this decision because they're not being given an appropriate time to bond with their child. So they'll either have to choose their career or they'll either have to choose their child. Again, this was being violated. And then Article 21 was also being violated, right to life and personal liberty. So motherhood, when we talk about motherhood, it should also be dignified. These new mothers need to have this time to develop the bond with the baby, and the baby also has this right to be taken care of, to be properly taken care of. It is also the child's right to be properly taken care of. That's why it was a violation of Article 21 for the mother as well as for the child. So all these things, all these fundamental rights were being violated, and that's why the Supreme Court felt that this is unconstitutional and this needs to be struck down. And apart from all this, the Supreme Court also said that we need to be mindful of the ground realities as well. There are a lot of legal hurdles, legal delays when it comes to adoption. We know we have CARA, Central Adoption Resource Authority, that deals with the adoption process in India. And many a times what happens that for children who are orphaned, some 2 to 4 months are already gone before these children are ready to be adopted. So 2 to 4 months are already gone in case of orphaned children. And when we talk of children who are being surrendered by their biological parents, so they're not orphaned, but the biological parents want to give away their children. They are being surrendered. They are being surrendered. In that case also, these parents are given a 60-day reconsideration period to reconsider their surrender decision. So again, 2 months have passed. Here also 2 to 4 months have already passed. So this 3-month threshold or the 3-month criteria that we had was mostly not fulfilled. Then most of the adoptive mothers, they were not getting this maternity benefit because of the legal hurdles, the legal delays, the administrative delays that we have in the adoption process. So the Supreme Court said that we need to be mindful of these delays also. And that's why also this 3 months period has been struck down. And now when we talk of maternity leaves, it is 26 weeks for all the biological mothers, for government and private employees, for first 2 children. After that, it comes down to 12 weeks. And there's an additional childcare leave also that's being provided. And when we talk of adoptive mothers, it is 12 weeks, irrespective of the age of the adopted child. And we also need to discuss the paternity leave status in India, because when we talk of developing an emotional bond with the child or nurturing the child, it is actually the job of both the parents. Both the parents need to nurture the child together, and they should be given adequate time to do that. So when we talk about paternity leaves in India, there is no universal law. Like we have a maternity leaves law of 26 weeks, there is no universal law that we have. For government employees, there's a provision of 15 days of paternity leave. And there is no such mandatory thing for private employees. It is at the discretion of the private employers. Now, this is a loophole, a lacuna that we have in our system right now, wherein both the parents do not get adequate time to develop this bond with the child. So paternity leave status also is something that India needs to revisit and come up with a universal law in this regard as well. So that was all for this discussion. I hope you enjoyed the video. Now we will look at a practice question for prelims. With reference to maternity benefits in India, consider the following statements. 1. Under the Maternity Benefit Act 1961, maternity leave of 26 weeks is available for all children without any limit. 2. Government employees are entitled to child care leave in addition to maternity leave. 3. India has a statutory law mandating paternity leave for all private sector employees. Choose the correct statements. A. 1 and 2 only. B. 2 only. C. 2 and 3 only. Or D. 1, 2 and 3. Please attempt this question and provide your answers in the comment section. Thank you for watching.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.